625-684.
I can hear you, Mr. Bear. Were you testing?
Oh.
So good afternoon. Before I call our hearing, let me just check in with the court reporter. Harriet, are you there and are you ready?
I'm ready if I can get my finger to the right place, but I'm ready.
Okay, I'll just hold on a second. I think we had somebody just now joining us. All right. I will go ahead and officially call proceeding number 24A-0344CP-EXT. This is a pre-hearing conference in the matter of the application of MedRide LLC for authority to extend operations under a Certificate of Public Convenience and Necessity number 55980. My name is Melody Mirbaba, and I am the administrative law judge who is assigned to hear this matter. This is a pre-hearing conference that was scheduled by decision number R24-0788-I, which was issued on October 31st, 2024. Before we get started, I'll just advise you all that consistent with commission practice, this hearing is being webcast and recorded. Webcast does include video and audio. We will continue to webcast if we do take any breaks, so please do keep that in mind. We also have a court reporter who is taking down everything that's being said. So to make sure she is able to do that, I'm going to ask everybody to keep your microphones muted until it is your turn to speak. Let's get started by finding out who we have here today. I'd like to start by taking entries of appearance. Let's start with MedRide LLC, who I'll refer to as MedRide.
Hello, Spencer Rubin, license number 49888, appearing on behalf of MedRide LLC. And Fortis Law Partners is our firm.
Thank you. All right, I want to turn next to the interveners who I styled in the decision as joint interveners, and that would be Alpine Taxi Limo Inc., AEX Inc., San Miguel Mountain Ventures LLC, Wilderness Journeys Pagosa Inc., and Home James Transportation Ltd.
Good afternoon, Your Honor. Mark Valentine from the law firm of Keys and Fox on behalf of the joint interveners.
Thank you. And on behalf of Tava Cab LLC, doing business as Tava Cab.
Good afternoon, Your Honor. My name is Richard Barra, registration number 7886, appearing on behalf of Tava Cab LLC, DBA Tava Cab, and also on behalf of NDW Enterprises LLC, DBA Ski Town Transportation.
Great, thank you. And I'll refer to Tava Cab LLC as Tava Cab and NDW Enterprises LLC as Ski Town as necessary. Okay, so I scheduled this pre-hearing conference so that we could get a hearing scheduled and all the related procedural deadlines in place. I did advise in the decision the date by which the hearing needs to be held based upon our statutory deadline. And that was March 4th, 2025. I just first want to ask MedRide whether you've had a chance to confer with any of the other parties about a potential hearing date or anything else related to the schedule.
Thanks, Your Honor. We've conferred with both the joint interveners and Tava Cab and Ski Town Transportation, and we have come to a couple of options that we need to finalize here at our conference, and we're looking potentially at doing a hearing of about 5 days. And based on some of the interveners' schedules, we're looking at trying to make sure that we can accommodate everyone who would like to attend to be there, in addition to everyone's attorneys. But I can speak more to that, or I'll let the interveners and their attorneys speak to the proposed schedules. I'm ambivalent as to who wants to address that.
Why don't you go ahead and tell us what you all have discussed and agreed upon?
Okay, sounds good. Thank you, Your Honor. So Mr. Valentine and I and our co-counsel, Ms. Plimpton, who's unable to attend today, we discussed having a 5-day hearing that would span the Monday, Tuesday, Wednesday, Thursday, which would be the last week of February. So let me pull those dates up right here so I can tell you what that proposal is. We'll probably have to amend it. But that original proposal would have been February 24th, 25th, 26th, 27th. And then there was a scheduling conflict on February 28th, so concluding on Monday, March 3rd. We also conferred with Mr. Barra, representing TABA and Ski-Town Transportation. And because Ski-Town Transportation has a busy season in February and March, as you can imagine, with doing transportation for folks who are skiing in Steamboat Springs, his client has requested that we do hearings only on Tuesday, Wednesday, and Thursday, because Monday and Friday are busy transportation days for long weekends in the Ski-Town area. So we did not approach a different timeline with Mr. Valentine, but what Mr. Barra and I had discussed yesterday was potentially moving this so it would start a week earlier on February 18th, 19th, 20th, and then moving into the next 2 days on the 25th and 26th, which would accommodate Ski-Town Transportation, but I'm not quite sure what Mr. Valentine's schedule looks like or his clients.
Okay, Mr. Valentine, the dates that I just wrote down are February 18th, 19th, 20th, 25th, and 26th. Mr. Rubin, if I got that wrong, feel free to speak up. So Mr. Valentine, how do those dates look for you?
Those work for me, Your Honor. I can make those dates. I'll double check with my clients. But I don't anticipate a problem.
Okay, great. And Mr. Barra, those are the dates you all agreed upon?
Yes, that would be great if we could accommodate my client. That would be wonderful.
Okay, let me just verify the commission's calendar can accommodate this. So I think we can manage this. The only tricky thing might be the 26th. On the 26th, we've got the commission's weekly meeting, and then there's a hearing that takes place almost at the same time in the middle of the day. So there could be a little bit of overlap. I would actually really prefer to avoid trying to juggle and manage that hearing date. Because of our other hearing rooms being occupied. I just can't guarantee that we get a full day on the 26th. So could we manage doing the 27th that week or the 24th? I understand that's not the preference, but we have to be able to get a full day of hearing in if we're going to do it. And
Well,
the
27th works for me, Your Honor.
Thank
It
you.
works for me as well, Your Honor.
Okay.
Your Honor, it works for me. I'm just confirming with co-counsel on the MedRide / Fortis Partners side. So if you could stand by,
Sure.
I'll try to get an answer while we are conferencing. But I think it will also work for our clients.
Okay. So pending confirmation, we're looking at a hearing on February 18th, 19th, 20th, 25th, and 27th. Next question is whether the parties reached any sort of agreement on the manner in which the hearing should be held, and that would be fully remote, in person, or hybrid.
Your Honor, I can speak to this too, since I spoke with Mr. Valentine and Mr. Barra separately. And again, we have a little bit of a difference in opinions. So I think that we'll need to align on that right here. So we and Mr. Valentine and his clients are aligned on doing it in person. That is MedRide's preference. We understand it to be joint interveners' preference. And I believe it's the preference also of Mr. Valentine and his law firm, Keys and Fox, as well as Fortis Law Partners. In speaking with Mr. Barra, that is not necessarily the preference because of some of the locations of his clients who would like to participate. So in person might be a little bit of a burden for them. And Mr. Barra's preference, I'll let him explain it further, if we can't do fully in person, would be fully remote, which is not necessarily MedRide or Fortis's preference in this matter. So individually, I can speak for our firm as well as MedRide. I would then advocate for a hybrid scenario, but I'm not quite sure how amenable that will be to everyone.
So in person in Denver or somewhere else?
In person in Denver.
Okay. Mr. Barra, would you like to state your client's position?
Yes, I have not heard back from my client. Mr. Rubin and I talked about the possibility of doing a hybrid, which would make everybody happy or everybody unhappy, depending on which way you looked at it. I've not heard back from my clients as to whether they would accept a hybrid, but it seems to me that that is the only solution we have because of the disparate areas of the various clients and the fact that we can't do individual hearings. We had already asked for that and you had denied that. So the alternative, I guess, would be a hybrid.
Yeah, I mean, I didn't outright deny it. I said it's going to be darn near, darn near
Well, it'd
impossible.
be very, I could understand the cost involved of setting up hearing dates. I know we had a problem last time we had to do a remote hearing outside of Denver. So I appreciate that. So, but I'm just telling you that I don't have a problem with a hybrid hearing, but I have, like I said, I have not officially gotten approval from either one of my clients.
Okay. And Mr. Valentine, did you have anything you wanted to add?
No, Your Honor, I'm amenable to a hybrid scenario. That's okay with me and my clients.
Okay. While I understand that people might prefer to be in person, I can tell you that from my perspective as a judge, I don't weigh the evidence any differently, whether somebody is testifying remotely or in person, especially since we have the technology to see everybody on the screen and, you know, see their faces while they're testifying. It just, there really isn't, in my view, much of a difference. So I don't, if anybody is concerned about appearing remotely and whether that's going to be a problem if we do a hybrid hearing, I can just tell you, I don't think that's going to make a difference in terms of at least how I look at the evidence and how I assess things. I just don't see any prejudice. And frankly, I do think that requiring people to drive all the way to Denver when they are in far remote locations, you know, it's just an unnecessary expense for the parties to have to incur, given the technology that we have and how easy it is for them to appear remotely. So with that in mind, I think we should set this as a hybrid hearing. That way, anybody who wants to come into Denver to appear in person is perfectly able and willing, they can do that. Anybody who prefers not to drive all the way to Denver can appear remotely. I'm going to ask that folks make sure they're able to do it via video conference. That is better. We can do it by telephone, but that is definitely not as easy and is not the preferred option. So, and there should be plenty of time for folks to be able to make arrangements to be able to do video conference. So, does anybody have any questions or anything you'd like to add on that?
No.
Okay. I will be establishing a deadline because I will tell you in my experience, sometimes what happens is we get closer to a hearing, especially when hearings are in the winter. I end up finding out that everybody has changed their minds and they don't want to drive and they just want to appear fully remotely. And I am not, you know, for a hybrid hearing, I have to go downtown. I have to be in person and I am not going to sit in a hearing room by myself if everybody decides to appear remotely. So I will set a deadline it'll be 2 weeks prior to the first date of hearing, and I will require a MedRide to confer with everybody and only make a filing if that conferral results in you learning that nobody plans to appear in person, that everybody has changed their minds. And if everybody has changed their minds, which is fine, I will issue a decision converting this to a fully remote hearing. And I promise I will not hold it against you if that's what you decide to do. I understand that things can change over time and people's views on this might change when there's a major winter storm. So that deadline, since the first day of hearing is February 18th, let me just look at the calendar. I'm going to make that deadline February 3rd. And that filing only has to be made if nobody is going to appear in person. If at least one party will appear in person, we'll hold it as a hybrid hearing. Okay, now the next deadlines I'm going to establish relate to filing and serving exhibits, exhibit lists, and witness lists. And the way I have been doing this is just to make sure that we don't have any, I don't surprises. I want to give parties the opportunity to look at what the other side plans to intends to present as evidence first, and have the ability to supplement what they plan to what they plan to present during the hearing. So what I'm going to do is I'm going to establish a deadline for those initial disclosures to be made, and then another deadline, if the parties so desire, to file an amended exhibit and witness list and additional exhibits. They're all going to be simultaneous, so everybody will have the same amount of time to decide if they want to add any more exhibits. So in looking at the calendar, let me just take a quick look here and figure out what the initial deadline should be. Okay, so that initial deadline is going to be January 20th. Let me just make sure that is not a holiday. It is a holiday. Great. So that will be January 21st.
25th,
21st.
21st.
Yeah, it's on a Tuesday. That's about a month before the first day of hearing. Okay, and then if anybody wishes to file an amended exhibit and witness list and add exhibits, that disclosure will have to be made by February 4th. Which is precisely 2 weeks prior to the start of the first day of hearing. That should allow the parties enough time based on this schedule to prepare for the hearing. And I will put this in my written decision, but I do want to be clear that if anybody wishes to add exhibits after doing the initial exhibit list and exhibit disclosures, that the amended exhibit list and witness list need to be complete. I don't want to see it as a supplemental. I don't want to have to pull the first one and then take the other one and have to look at them both to figure out what all the documents are that you want to present, all the witnesses that you want to present. It'll just make it easier if it's a completely amended document that replaces the original one. Statements of positions. Would the parties like to submit statements of position? Mr. Rubin, I don't think I've had you in any of my cases before, so I'll just explain in case you're not familiar. And the commission, a statement of position is essentially a written closing argument And so what that means is that you won't be doing verbal closing arguments at the hearing. You'll just be submitting a written statement of position. Would the parties like the opportunity to submit statements of position?
We did that in the most recent proceeding that we had before the PUC, so we're going to reserve the right to do that this time as well.
Okay, so let me set a deadline for that. All right, that deadline will be March 14th. A little over 2 weeks after the last day of hearing. Mr. Barr, did you have something that you wanted to?
No, I was just, for some reason, I'm having bad reception, so I'm having a little trouble hearing you. So I'm kind of straining. That's why I'm making these contorted motions.
Okay, I'll try to speak loudly. That in terms of what I had in my notes, I think that's all the deadlines that I needed to set. I also just want to note for the record that I did review the updated letters of authority that Home James Transportation and AEX Inc. filed yesterday, and they confirmed that they have properly intervened of right. That does not change. In other words, they don't change anything that I've already ruled in terms of those interventions. They will continue to be interveners. I'll just say to Mr. Valentine, you've been practicing with us for quite a long time. I'm just going to ask you in the future to please remember to make sure your clients are giving you and you are filing their most recent updated letters of authority. Everybody should be doing that. I shouldn't have to point it out.
Point taken, Your Honor. I've updated my bank of authorities here.
Thank you. Thank you. Appreciate that. Now, is there anything else that we should, that we need to address before we adjourn our hearing?
I'll just address it so you know, Your Honor. I already spoke with Mr. Barr and Mr. Valentine about this, but I'm a corporate attorney and I am newer to Fortis. I practice in our corporate group, and because our client MedRide is so busy with the matters that they send us, I am stepping in to help our litigation team. So I am very nubile when it comes to adversarial proceedings and disputes, especially practice before the PUC. So one, thank you for your patience as I probably muddled through some of the filings in terms of applications and amendments. Obviously, you were not the first person who reviewed them, but you know, your points in the order that you issued were well taken as well. So thank you for your patience. And thanks for everyone in the conference's patience with me as I do this. Co-counsel will be joining me in the future. But again, given our schedules, I will sub in and lead as necessary. So if for whatever reason I am unfamiliar with a rule or decorum or the way in which anyone should be addressed or introductions or anything that's even minute, please just correct me and let me know, because it's a good learning process for me. And I want to be transparent with everyone. Obviously, we're going to give MedRide the best representation that we can on our side, but I figured I would let everyone know that normally I sit behind a desk all day with contracts. So new for me.
Well, hopefully that experience might come in handy to help you all reach an agreement. I am certainly holding out hope. I think there have already been several agreements that have reached, have narrowed, you know, the parties that are objecting. So I'd say maybe that experience will help you guys talk and perhaps reach an agreement that would avoid the need. This is a pretty, it's a lot of days of hearing. It's going to cost clients a lot of money to do this. So it seems to always be in everybody's best interest to see where they can find common ground. And even if we can narrow the scope, that's always helpful. Since you brought up that you don't litigate very often, I'll give you a couple of things to think about, or just really for everybody. You know, the commission, we have some unique practices. I would suggest you take a look at the commission's rules of practice and procedure that are available on our website. We also have the transportation rules that are available on the website that'll provide background on, you know, legal standards and what needs to be proven for an application to be granted. During the evidentiary hearing, I'll just say the commission typically does not allow for friendly cross-examination. So that's, I guess, more of something I'm directing at interveners. So we don't really do friendly cross-examination. Outside of that, the other sort of, I'd say, unique thing that we will do, and this will be written up in my decision, is that because we're doing everything, we're doing this as a hybrid hearing. All the evidence is going to have to be presented electronically. And so we have some unique processes to allow for that. You'll be receiving an email to basically create, if you don't already have one, a free box.com account. And that's where everybody is going to need to put any exhibits they plan to offer under evidence into that account. And during the hearing, we receive the exhibits into evidence electronically from those box.com accounts. We will have, I'll have a legal assistant that helps us during the hearing. The attorney during the hearing will identify the hearing exhibit number that they want to present. The legal assistant can access it in your box.com account. None of the other parties will be able to access anything you put in that account. So if you have, for example, an exhibit that you may use for impeachment, you don't know if you're going to use it, depends on what happens during the hearing. You can put it in there and the other parties will not see it, but it will be available, and it has to be available in order for us to be able to pull it up, open it. So we will then receive exhibits electronically via the box.com accounts. And then after the hearing, all those exhibits that we received electronically get added to our record through administrative support staff. So the exhibits will sometimes be in there more than once, but it becomes pretty clear that those are the ones that were admitted into evidence. Sometimes people may modify an exhibit between the time it was initially filed and the time that it admitted into evidence. So that's yet another reason why we do that. So it's very clear what was the evidence that was admitted into the record. You can, the decision that I issue will have some contact information for our legal assistants who can provide additional support and background if you get concerned about whether you can manage this electronically. We are going to be in person, but that you still are going to have to be, we're still going to be pulling everything up electronically. So I would advise that if you're coming in person, bring your laptop, we'll have internet access, you'll be able to see it on your screen. We have large monitors in our hearing rooms, so exhibits will be displayed onto those monitors. People in person will be able to see them on the monitors as well. People who are appearing remotely will be able to see it because it will be on the Zoom screen as well. The witnesses who are not in person, I highly advise, and this will most likely be required in my decision, that you make sure they are able to download documents electronically from where they are, because sometimes they have a hard time seeing it on the screen and they need to see it on bigger, and they can only do that if they download it. Another thing that can be done for witnesses who might have some technical problems is you'll have notice of all the documents that every party is going to offer into evidence before the hearing, and you can actually print them out and mail them those paper copies so they can have those in hand and refer to those. I'm not going to allow witnesses during the hearing to refer to documents unless they've been directed to do so. So you might want to advise them. Nobody can sit there and read from a script while they're testifying. And they can't get help from anybody while they're testifying. That's how it would be in a courtroom. So we do it the same way when they're appearing remotely. That's pretty much all I can think of that you just might want to be aware of. You might also want to just get on our public calendar and see what other hearings might be scheduled and observe a few hearings to see if we have some unique processes you need to familiarize yourself with. Mr. Barra and Mr. Valentine, they've done tons of hearings with us, so this should all be pretty familiar, but I'll pause to see if either of you, if there's anything else you want to bring up or mention along these lines. I personally want to do everything I can to make this a smooth hearing process for everyone.
Thank you, Your Honor. Lord knows I have my difficulties with the electronic system sometimes, so appreciate it.
Sure.
Same here. I'm not that great on that electronic stuff.
Mr. Barra, you've really improved. I know you were very hesitant at first when we started doing it this way, but you've been doing great. So,
Well, thank you. Appreciate it.
Don't doubt yourself. Just keep at it. The one really important thing, and this will be in my decision, is that any document that you even might present has to be marked with an exhibit number. Even if you don't end up presenting it, even if you think it's just demonstrative, I have to have a number on it, so I have a way of there's a way to refer to it in the record. It's going to be in the record eventually. So whatever you think it is or isn't, mark it. If you want to present it, mark it with an exhibit number. My decision is going to assign exhibit numbers so that everybody, we don't have confusion about the numbers and how those should be marked. And the decision will explain all those levels of detail. So when you get it, please pay very close attention to that. And we'll have time between now and the hearing if there are questions or issues to be brought up. All right, is there anything else we need to address before we conclude?
Not for me, Your Honor.
I'm set. Thank you.
None for me. Thank you, Your Honor.
All right, then. Thank you all for appearing, and I will issue a written decision memorializing all of this, like probably within the next week.
Thank you.
All right,
Thank you.
thank you all.
Thank you.
Have a nice afternoon.
You too.
Thank you.